Good.
All right, Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his name? There's a bond by.
Yeah, no, I see it. Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do
To
that?
consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date. I mean, then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
You wrote Pickett.
I understand all of that, but my other problem is that given the other sort of mistest, I mean, what about you say the twisted tea on the 13th? What about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Country.
Well, I just said that, but you're welcome to say it if you'd like to.
No, I didn't. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I
So
was.
I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7. Maybe
Yeah.
8. I had 2 missed tests while I was in the hospital, but I did, yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking.
Yes,
Quite frankly, need to go inpatient.
You're
I mean, you know you can't do this on your own.
correct, sir.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing?
This hearing starts off deceptively simple, but it spirals fast. What you're about to watch is a textbook example of how denial, addiction, and poor judgment collide in a courtroom, and how quickly sympathy can evaporate when facts start stacking up. This defendant isn't here on a minor technicality. He's already on bond. He's already under court supervision. And he's already been warned. Yet here he is, admitting to alcohol use while trying to minimize what's actually happening behind the scenes. The judge is calm. The attorneys are professional. But underneath that calm surface, this case is flashing warning signs everywhere. Missed tests. Positive alcohol results. Repeated violations. And a defendant who keeps framing relapse as a misunderstanding instead of a breach of trust. As this hearing unfolds, pay attention to how the story changes, from just one drink to a pattern that paints a much darker picture. And when the real allegations come out, everything flips. This is one of those hearings where the courtroom stops negotiating with
Would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs a drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
People have some concerns if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody.
Right here, you can already see the strategy forming. Admit just enough to seem honest, but not enough to trigger consequences. The defense leans heavily on the idea that he's self-reported, that he was transparent, that he's trying. And to be fair, admission does matter, but only up to a point. The problem is this isn't a first slip. This is a pattern. Multiple dates. Multiple missed tests. Multiple positive results. What stands out is how casually alcohol use is being discussed, almost like it's a footnote instead of a direct violation of bond conditions. Courts don't view substance use in a vacuum. They view it through the lens of risk, compliance, and credibility. And every time the defendant explains instead of owning the behavior, credibility erodes a little more. This is the moment where the judge is no longer just listening. They're evaluating whether this person can be trusted outside of custody at all.
My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a straight tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations,
This is where the emotional weight comes in. The defendant openly admits he relapsed after 4 years sober. And that's real. Addiction is real. Relapse is real. Courts understand that. But what courts don't accept is continued risk without accountability. Notice how the defendant frames his relapse as a personal struggle rather than a legal violation. That distinction matters. The judge isn't dismissing his honesty. But honesty doesn't cancel consequences, especially when bond conditions exist specifically to prevent escalation. This is also where the court starts connecting dots. Missed tests don't look accidental anymore, they look intentional. And when intent enters the picture, the tone of the hearing changes. The sympathy window starts closing fast. This is the turning point. Once the judge lays out the timeline, August 30th, September 13th, multiple missed tests, the one drink narrative collapses. 6 or 7 times drinking isn't a slip. It's a pattern. And when the judge calls out manipulation of testing, that's huge. Courts rely on testing to assess compliance. When someone starts gaming that system, trust is gone. You can hear it in the judge's voice. This is no longer about whether help is needed, it's about whether the defendant is capable of staying compliant without being locked down. And the answer, based on this record, is becoming painfully obvious.